Good day to each and everyone, especially to you, ma'am. Today, I am going to report to Chapter 4 entitled Law on Partnerships and Corporations on the subject legal aspects in tourism and hospitality. So let's start with our learning objectives. So first is to differentiate the various kinds of partnerships and corporations and the responsibilities of partners and incorporators. Second is to identify the requirements in the formation and dissolution of partnerships and corporations. In a high-level industry like the tourism sector, it is imperative that it is strictly complies with legal requirements in order to operate as a legitimate business. Startup operations must have a strong foundation, and in order to have a strong foundation, you must start with a strong business organization. Forming a partnership or a corporation is a better choice in forming business organizations in order to enter a competitive industry like the tourism industry. This chapter will present an overview of a partnership and a corporation as a business organization. The law on partnership is governed by the Civil Code of the Philippines, while the law on corporation is governed by the Batas Pambansa Bilang 68, or what we call as Corporation Code of the Philippines. Then let's proceed on the law on partnership. In Article 1767, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So, a partnership is an association of two or more persons to carry on as co-owners of the business for profit. The definition of a partnership does not include religious associations, conjugal partnerships, and others of a similar nature, because a partnership as defined by law refers only to associations the purpose of which is to obtain profits to be distributed among the partners. A partnership contract is based on trust and confidence. Hence, the fiduciary relation in a partnership stems for the principle of dilectus personae, wherein no one can become a partner in a partnership without the consent of all the partners. Next is the essential requisites of a partnership are: first, in agreement to contribute money, property, or industry to a common fund. This is to complied with if each one of the partners brings or is obliged to bring something to the partnership, and that which is brought becomes common property. And next is in the intent to divide the profits among themselves. This is to comply with if a partnership is established to obtain profits. Profit must be common to all the parties, and profit or loss must be divided among the partners. Next is the advantages and disadvantages of forming a partnership. Let's tackle first the advantages. The advantages of forming a partnership are easy to form, improved growth possibilities, and freedom from bureaucracy. And while the disadvantages of forming partnership are the instability, difficulty in obtaining large sums of capital, firm is tied to the acts and judgment of one partner as agent, and difficulty in severing partnership ties. Then we have the classifications of partnerships. We have the three. First classification is according to subject matter. We have the two, universal partnership and the particular partnership. Universal partnership is a partnership where all of the partners contribute all of their properties to the common fund, while the particular partnership is a partnership that has for its object determining things, their use or fruits, or a specific undertaking, or the exercise of a profession or a vacation. Next classification is according to liability. We have the two also, the general partnerships and the limited partnerships. General partnerships composed of general partners where liabilities extend to their personal properties, while limited partnership usually attaches the word Ltd or limited at the end of the company name, one formed by two or more persons having as members one or more general partners and or more limited partners, where the liability of the latter to the third persons is limited to their capital contribution. And last is according to its duration. We have the partnership for a fixed term is one which the term of its existence has been agreed upon expressly as when a particular enterprise or transaction is undertaken. the expiration of the term thus fixed, or the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. Next, let's proceed to the dissolution and winding up of a partnership. In Article 1830, dissolution is caused first is without violation of the agreement between the partners, second in contravention of the agreement between the partners where the circumstances do not permit a dissolution under any other provision of this article by the express will of any partner at any time. Third is by any event which makes it unlawful for the business of the partnerships to be carried on or for the members to carry it on in partnership. The fourth is when a specific thing a partner had promised to contribute to the partnership perishes before the partner who contributed it, having reserved the ownership thereof, has only transferred to the partnership the use or enjoyment of the same, but the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. Fifth is by the death of any partner. Next is by the insolvency of any partner or of the partnership. Seventh is by the civil interdiction of any partner. And lastly, by decree of court under the following article. Next, let's dive into the Article 1831. On application by or for a partner, the court shall decree a dissolution whenever: first, a partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. Second, a partner becomes in any other way incapable of performing his part of the partnership contract, and then partner has been guilty of such conduct as tends to affect prejudicially the carrying on of the business, and the business of the partnership can only be carried on at a loss. And next is a partner willfully or persistently commits breach of the partnership agreement or otherwise so conducts himself in matters relating to the partnership business that is not reasonably practicable to carry on the business in partnership with him. And last is other circumstances render dissolution equitable. And we have the order of liquidation for a general partnership. In Article 1839, in settling accounts between the partners after dissolution, the following rules shall be observed subject to any agreement to the contrary. We have the liabilities of the partnership shall rank in order of payment as follows: those owing to creditors other than the partners, those owing to partners other than for capital and profit, those owing to partners in respect of capital, and those owing to partners in respect of profits. Take note that the liquidation process under the above provisions applies only to a general partnership. There is a different process for the liquidation of a limited partnership. And let's tackle the order of liquidation for limited partnerships. According to Article 1863, in settling accounts after dissolution of liabilities of the partnerships shall be entitled to payment in the following order. First, those to creditors in the order of priority as provided by law, except those to limited partners on account of their contributions and to general partners. Second, those to limited partners in respect to their share of the profits and other compensation by way of income on their contributions. Third, those to limited partners in respect to the capital of their contributions. Fourth, those to general partners other than for capital contribution. And fifth, those to general partners in respect to profits. And lastly, those to general partners in respect for capital. The above provisions expressly provides for priority in the distribution of assets after dissolution of a limited partnerships. Those due to creditors under number 1 Article 1863 are the outside creditors, including those owing to the limited partners. In the absence of any statement in the certificate as to the share in the profits for which each partner shall receive, a limited partner shares in the profits shall be a proportion to the amount of the partner's respective capital contribution. This proportional sharing takes place where the partner's assets are insufficient to pay each of the partners. And now, let's proceed on the law on corporation. In Section 2, corporation defined as an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. In the Philippines, the law which governs the creation of the private corporation is the Batas Pambansa Bilang 68, known as the Corporation Code of the Philippines. Right of succession means that our corporation has the capacity to exist regardless of the death, withdrawal, insolvency, or incapacity of the individual stockholders, and regardless of the transfer of interest of shares of the stock. The powers of all corporations are limited to those mentioned in their charters or in the general acts under which they are created. And here we have the 10 kinds of corporation. First kind is the stock corporation. Stock corporation is one which has a capital stock divided into shares and is authorized to distribute to the holders of such shares or dividends. Next, the non-stock corporation is one that not organized for profit. The governing body is usually the board of trustees. And third is the corporation de jure, a corporation where a corporation organized in accordance with the requirements of the law. And next, the de facto corporation. It is a corporation where there exists a flaw in its corporation. And we have also the public corporation. It is created by its own charter for the exercise of a public function. And next is the private corporation, one formed for some private purpose, aim, or end. It is created by incorporation under the General Corporation Law. Next is the corporation sole. In this corporation, there is only one incorporator. That's why it is corporation sole. It means only one. Next is the eleemosynary corporation, one organized for a charitable purpose. And we have also the domestic corporation. It is a corporation formed, organized, and existing under the laws of the Philippines. And lastly, we have the foreign corporation. It is a corporation formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in their own country or state. And let's proceed on the advantages of a corporate organization. First is the strong separate juridical personality, limited liability to investors, free transferability of units of ownership, centralized management through the board of directors, professionalism, and easier to sell small amounts of stock to raise capital. While its disadvantages of a corporate organization are extensive government regulation, double taxation, and activities are limited by charter and various laws. Then we have the contents of the articles of incorporation. We have there the name of the corporation, the specific purpose or purposes for which the corporation was incorporated, the place where the principal office of the corporation is located, which must be within the Philippines, and the term for which the corporation is to exist. The term of the corporation shall be for 50 years, which can be extended for another 50 years, including also the names, nationalities, and residences of the incorporators. An incorporator is defined as one who institutes the steps necessary to form a corporation and is an original member of it. Next, including also the names, nationalities, and residences of the incorporating board of directors until the first regular directors or trustees are duly elected and qualified. And lastly, we include also the authorized capital stock and the amounts subscribed and paid by the stockholders or incorporators. According to Article 1, we consider the subscription, issuance, and transfer of shares and the lost certificates. In Section 1, it is about the subscriptions. Subscribers to the capital stock of the corporation shall pay to the corporation of subscription value or price of the stock in accordance with the terms and conditions prescribed by the Board of Directors. Unpaid subscriptions shall not earn interest unless determined by the Board of Directors. In Section 2, certificate, each stockholder shall be entitled to one or more certificates for such fully paid stock subscription in his name in the books of the corporation. The certificates shall contain the matters required by law and the articles of incorporation.